concerned about the speed at which this bill is being processed, and we hope that stakeholders will be given sufficient time to give their input, especially because of the implications of such a bill. Now let's look at some of the implications. While ostensibly seeking to prevent, this bill severely limits the ability of Ugandan citizens to exercise or enjoy their fundamental rights and freedoms. It fails to meet the constitutional threshold required for such limitations by Article 43 of our Constitution as below. 1. Whereas on the surface, the bill states in its objectives that it aims at protecting the sovereignty of Uganda and its citizens, it collapses under scrutiny. 1. The bill conflates the interests of a sitting government with the interests of the wider public. This is seen, for example, in clauses such as Clause 2(2)g and Clause 8(3), which prohibit citizens from influencing the public to oppose a policy of government and from hindering or disrupting the implementation of government policy, respectively. Honorable Chair, our duty as the opposition, for example, whether we are in Uganda or abroad, is to oppose government policy. That's why we are there as the opposition, to oppose what the present government is doing. What this bill is saying is that if someone is opposed to public policy and you're a foreigner, and I'll come to that, then you are committing a crime. This bill is essentially criminalizing opposition. We know that in Uganda, opposition has already been criminalized, but once you say, that citizens should not influence public policy or oppose the policy of government, then I think that's extremely unconstitutional. The bill targets conduct that is already regulated by existing laws, as we already submitted above. The public interest apparently claimed in the bill's memorandum, that is, of filling legal gaps, is therefore factually false in the face of the existing laws. C. Several provisions of the bill have no conceivable public interest anchor. For instance, Clause 2(2)g, which implicitly requires anyone who influences the public to oppose a policy of government to first seek approval of that government, does not, protect any public good. Instead, it shields policy of that government from public criticism, thereby unjustifiably limiting the public's freedom of speech and its right to participate in the affairs of government. This clause alone effectively bans the political opposition, like I've said. Even where such public interest exists, demonstrably justifiable in a free and democratic society as envisaged by Article 43(2)(a) of the Constitution. For example, in this bill, under clauses 3, 4, 6, 6, 14(1), 15, 16, etc. of the bill, these clauses effectively place entire regulatory and enforcement mechanisms of the bill under the direct control and or guidance of the Minister of Internal Affairs, a political appointee, who is appointed by and answerable to a sitting president. The said clauses grant the minister wide discretion to register, deregister, refuse, suspend, or revoke the operational certificates of anyone deemed to be an agent of a foreigner, with no meaningful procedural safeguards to restrain the existence of that power, the exercise of that power. This exposes opposition politicians, NGOs, investigative journalists, researchers, whistleblowers, and other real and perceived opponents of the minister and his appointing authority to political persecution. Therefore, these limitations are disproportionate and thus unjustifiable. As we have stated above, the objectives stated in the bill do not match the provisions therein enacted. In our view, for example, clauses 5, 3, 7, 4, 8, 3, 10, 12, 13, 14, and 22 of the bill effectively suppress dissent instead of protecting the self-determination of the people of Uganda. We also consider the following clauses to be overly broad and disproportionate for the reasons indicated against each. The definition of a foreigner under clause 1 of the bill is as ridiculous as it is the foundational source of the bill's overbreadth. Every substantive offense in the bill is construed around this definition of a foreigner, meaning that it is disproportionate, that which infects almost every provision. Our view is that once you begin with a definition of a foreigner in that manner, that particular provision affects the rest of the bill, and that is why we oppose it in its entirety. The definition is unconstitutional because, first, it includes Ugandan citizens residing out of Uganda. It means, Mr. Honorable Chair, that if a Ugandan goes on a plane or moves by any other means out of Uganda, that person at that point has become a foreigner. How ridiculous. This provision is unconstitutional. It renders these people foreigners in their own country by their mere fact of physical location abroad. The presupposition is that maybe they should even abandon their passports. That once you move out of Uganda, even if you have a Ugandan passport, at that point you've become a foreigner. Any Ugandan in the diaspora who sends money to their family or funds a political campaign or communicates political views to relatives at home is considered a foreigner. And thus, whoever is based in Uganda who wishes to deal with him or her requires ministerial permission. Second, and most critically, the definition empowers a minister to declare any person or body a foreigner. This delegation grants a minister open-ended power to expand the definition of a foreigner to capture any individual organization at will without any defined criteria. Such a definition, which can be expanded by ministerial decree at any time, provides no legal certainty whatsoever, thereby violating the right to a fair trial and the principle of legality. It is also ridiculous because it implies that even government officials who go out of the country on official duties automatically become foreigners who are then forbidden to conduct the business of the state. Now, close the problems with this bill, Honorable Chair, and why we think it should be thrown out, is the nature in which it defines or it sets principles very, very broadly and therefore subjects them to abuse at any point. Consider 5.3, in which the phrase interests of Uganda. Who defines what interests of Uganda are? You know, it renders the related offense vague. This violates citizens' right to free speech and association, because everybody will be asking themselves if what I'm going to say, whether what I'm going to say is contrary to the interests of Uganda or not, because who defines what the interests of Uganda amounts to? Clause 6.1 and 2 require cabinet approval before any person performs functions ordinarily the responsibility of government, as listed in the 6th schedule to the Constitution, cripple legitimate NGO service delivery in sectors like health and education, in disproportionate violation of citizens' freedom of association, right to work, civic participation, etc. Clause 7.3 criminalizes policy development without cabinet approval. Can you imagine? Thus effectively outlawing opposition manifestos, academic policy work, research, which is disproportionate violation of citizens' freedom of expression, thought, and opinion. Clause 8.3 prohibits acts that hinder or disrupt government policy implementation without necessarily requiring unlawfulness or harm. Left as it is, this clause converts such actions as democratic opposition, litigation, and even journalism into criminal conduct, which constitutes a disproportionate violation of the freedom of expression and the freedom of assembly. Clause 11.2 prohibits foreign-linked influence over our elections. Honorable Chair, that's very, very problematic. Now, when you read that and compare it to the definition of the foreigner in Clause 1, and then the bill is saying that, you know, foreigners should not influence our elections. And these foreigners include Ugandans in the diaspora. So does that mean that Ugandans in the diaspora should now not have a say in how elections are run? In any case, the High Court of Uganda has already declared that Ugandans in the diaspora should be given an opportunity to even vote. But as you know, that right has not been implemented by the Electoral Commission and other agencies. So it's ridiculous to say that if a foreigner is, you know, influencing elections in Uganda, and then with that broad definition of a foreigner, it is very, very problematic. Right to vote and participation in electoral processes. Clause 12.1 prohibits any meeting aimed at interfering with government operations without establishing a threshold for when such a meeting would become unlawful, effectively outlaws opposition political rallies, trade union activities, etc., in violation of freedoms protected by Articles 29, 1A and D and 43 of the Constitution of Uganda. Clause 13 makes it an offense for anyone to publish any information, even if it may be true, or participate in any act that weakens or damages the economic system or viability of the country, causing economic disruption, insecurity, or instability. How do you define this? It is so broad that the government will wake up one day and choose to interpret it in any way it desires. Besides being vague, this provision suppresses journalism and political criticism, which disproportionately violates citizens' right to speak freely and access to information, as well as Article 43 itself, as no legitimate democratic society criminalizes truthful publication. Clause 22.1 imposes a funding cap of 400 million per 12 months on affected organizations, and that is likely to cripple activities of such organizations as opposed to encouraging them. You know, Honorable Chair, for example, the National Unity Platform irregularly has been prohibited from getting public funds that it ordinarily should be entitled to. That's a debate for another day. So what this bill is saying is that NUP as a political party should not be receiving funding of this magnitude, you know, from what it is defining as a foreigner. Effectively, you're saying we have crippled you internally and even crippled your probable sources. You know, if Ugandans in the diaspora collect money collectively and want to send it in one go, this bill says that is a crime being committed. So, which again makes the intentions of the bill suspect. Clause 23.1, which defines disruptive activities to include political expression and civil society. You know, everybody knows that in this country, you cannot, as an opposition party, write to the police seeking to demonstrate in Kampala and you get clearance, even when the law does not require that you get clearance. So, in other words, demonstrations in Uganda have practically been rendered unlawful, every kind. But now, this bill is saying that any encouragement of demonstrations, you know, by a foreigner is unconstitutional, is criminalized. So this violates the freedoms of assembly and association, as well as Uganda's obligations under regional and international charters. Further, there is no rational connection between the harsh penalties proposed in the bill and protecting Uganda's sovereignty. As a means, the bill chooses to do so are grossly disproportionate to the ends it purportedly seeks to achieve. We accordingly find these penalties ridiculous. Clause 5.4 proposes a fine of up to 2 billion or 20 years imprisonment, or both, for promoting interests of a foreigner, which again has not been defined. Clause 6.4 proposes a fine of up to 2 billion or 20 years imprisonment, or both, for exercising government functions without approval. Clause 7.4 proposes a fine of 2 billion or 20 years imprisonment, or both, for developing policy without cabinet approval. Other clauses in this category are 10.2, 11.3, 12.2, 13, 14, 22, 26, etc. Even if one were to assume that the objectives and provisions of the bill are legitimate, which are not, the penalties proposed by these clauses are nevertheless excessive, high-handed, and suspicious altogether. Rather than using the most minimal options available to limit the rights of Ugandan citizens in pursuit of its stated objectives of protecting our sovereignty, the bill instead resorts to the most restrictive options, such as criminal prosecution with very long prison sentences and steep fines. Yet less restrictive means would have served the stated purpose, and in fact our argument is that the present laws do that. In conclusion, the protection of sovereignty bill is unconstitutional and dangerous, not only undermined by the existence of adequate legislation already in place, but it also directly contradicts the bill's operative provisions, which systematically dismantle the very fabric of civic, political, and associational rights and freedoms through which the people of Uganda meaningfully exercise their sovereignty. The bill concentrates unchecked executive power in the Ministry of Internal Affairs and criminalizes ordinary democratic participation. It imposes penalties too severe to be considered merely regulatory and defines foreigner in such an absurd and expansive manner that renders every substantive provision anchored on the definition to be constitutionally defective. We accordingly call upon the committee to reject the bill in its entirety and recommend its withdrawal to the House. The National Unity Platform, I've seen some people say that this bill definitely targets the opposition right now as it is, especially because of our engagement with the Ugandan diaspora, and because the present government has tried and done everything possible to limit the operations of, for example, the National Unity Platform internally. So when they see Honorable Kyagulanyi, our president, addressing the EU Parliament on what has gone wrong in Uganda, they feel that they need to bring such a law. Our advice to them would be to correct what has gone wrong. Instead of trying to come up with all these laws to criminalize every legitimate political participation and activities of the opposition, let them do the right thing. Let them ensure that elections are free and fair. Let them stop abductions. Let them ensure that Ugandans can enjoy their freedoms and rights as enshrined under the Constitution. If they do that, there will be no need, for the opposition to even do what we are doing. But this law, as it is persecutorial in nature. It is intended to persecute and not to achieve any other objective. I thank you. And again, we have submitted both our own and also a memorandum from the diaspora. Thank you, Honorable Chair.
Thank you, Comrade Lewis.